Thus, we are going to discuss the Introduction to Land Governance paper that was done in August 2023, Foundation Level for KASNEB. Foundation Level KASNEB, Introduction to Land Governance, the August 2023 paper. And we'll go straight away to question 2. Start with 2A. So outline 3 types of freehold interests in land. Outline 3 types of freehold interests in land. So we'll go straight into outlining the 3 types of freehold interests into land. In land, the first one is the fee simple absolute. Fee simple absolute. This type of freehold interest grants the ownership title, or rather the property owner grants the ownership title to the property owner in perpetuity. Grants the ownership title to the property owner in perpetuity. So the property owner holds the ownership title, the title to the property in perpetuity. Perpetuity means that he can pass it over even to his heirs. So for this is a type of land that can be passed over from one generation to another, because the owner has absolute rights. He has rights of that property in perpetuity. Perpetuity means for as long as it takes. So if he passes on, he simply leaves the property to the next generation or to his descendants or heirs. The one thing though stands that the property, of course, has to be used within the laws of the land, the laws of the land, and it should not violate the active easements that have been set against it. So otherwise, the title belongs to the owner, and because it belongs to the owner in perpetuity, it can be passed over to the heirs. That is fee simple absolute. Then number 2, we have the fee simple defeasible, or fee simple detainable, or we can also call it the base fee. It's also called the base fee or qualified fee estate. Qualified fee estate, base fee, fee simple defeasible, fee simple detainable. It can go by any of those names. That will be our second type of freehold interest in land. And this is where this is a type of freehold interest where the owner is granted title but with conditions. The owner is granted title but with conditions or parameters that he has to observe. If he violates any of those conditions, then he seizes the title, is of course taken back from, it's revoked, or it's reverted to the original owner. So you are only given title to use that land within the conditions or the parameters that have been set. If you go against or you violate the conditions, then that title will revert to the grantor, whoever gave you the title to the property. That is what we mean by fee simple defeasible or fee simple detainable. So this one, you can simply say that it grants the owner the title, it grants the owner the title, but with specific conditions or parameters to be met. So for example, you can be given a piece of land on a condition that you plant sugarcane in it. If you violate that condition and start planting something else, or start doing something else which was not provided for at that point in time when you are entering into that contract, then you will have violated the conditions, and that will mean that the property will revert to the grantor. So that is fee simple defeasible detainable. There are some conditions which come with the property and must be adhered to. Then we have the life estate, and this one, the ownership lasts for the duration of the life of the owner. The ownership will only be active to the extent of the owner's life. When the owner dies, then the ownership also lapses. So we'll simply say life estate, the ownership lasts for the duration. The ownership lasts for the duration of the owner's life. Ownership lasts for the duration of the owner's life. So when the owner dies, it simply means that the ownership rights also will disappear at that point in time when he dies. So these are the three types of freehold interest in land: fee simple absolute, fee simple defeasible, and the life estate. And we have gone ahead and given all the three explanations to the three freehold interest in land. So thank you. Let's go to the second part of this question. Highlight 5 characteristics of a promissory note. Highlight 5 characteristics of a promissory note. Highlight 5 characteristics of a promissory note. A promissory note is a negotiable instrument. And of course, it has its characteristics which distinguish it from any other negotiable instrument. And those are the characteristics that the question is asking. So we'll go straight into explaining this or highlighting these characteristics, and from them we'll be technically will have differentiated this particular negotiable instrument from any other. So the characteristics go a long way in defining what a promissory note is. So the first one, first characteristic is that it must be in written form. It must be in written form. That is the first characteristic, that it must be in written form, and it must be duly signed. Must be in written form, duly signed by the maker or the drawer. Must be in written form, duly signed by the maker or the drawer. So promissory note, the first characteristic is that it must be in written form and it must be signed by the maker or the drawer. Number 2, it must be duly stamped, and this is basically for authenticity. So it must be duly stamped with a stamp that is actually recognizable by the organization. So it must be duly stamped. Then number 3, it must contain an undertaking to pay a certain sum of amount, which of course should be mentioned therein. So it must contain another undertaking, and an undertaking is the same as a promise. So it must have that promise, must contain the promise or the undertaking to pay a certain amount of money, This is actually now the promise. So we cannot have a promissory note if there is no that promise in it to pay a certain sum of money. Normally we talk of a certain sum of money, certain debt, and all those things, type of stuff. So for this one, let's just say that it must contain a promise or undertaking an undertaking to pay a certain amount of money, which should be mentioned in that particular promissory note. Then it must also contain an unconditional promise. Perhaps we might, maybe for the sake of it, let's remove this one here. So let's say that it must contain an unconditional promise, or undertaking to pay a certain amount of money that should have been stated in the same promise or not. So this unconditional is very important, that it doesn't necessarily have to go with conditions, and that comes in as being a very key element in that contract. Then must contain consideration, in monetary terms. Consideration is the forbearance. There must be something that the other party possibly should have done to show that he's actually interested, or he values the contract. Then the other thing is that it should be payable on demand or at a certain date, which should be captured in that promissory note. So the date must be captured in the promissory note. So we are talking about the amount that will be paid must be captured in the promissory note. The date that the amount will be paid must also be captured in the promissory note. It must be an unconditional promise or undertaking that a certain amount of money will be paid in a certain date or time. And then we've also said that it must be in a written form and signed by the drawer or the maker of that promissory note. The other one possibly that we need to talk about here is that the sum payable must be certain. The sum payable must be certain. And the sum payable, we are talking about the principal. The principal should be very clear. The interest rate should also be very clear. The maturity date of that promissory note should be very clear. If possible, and if relevant, then we talk about the payment schedule. How will the payment be done? Then the date of payment, and perhaps you can also talk about the place of issuance. So the date and place of issuance, this one might also come in handy. And of course, the signature must never miss. So this is like just a summary of everything that we've said. So we are talking about the amount to be paid must be certain, and we are talking about the principal, the interest rate, the maturity date, the payment schedule, the place of issue, the signature. I think we've already talked about the signature. We've also talked about the amount payable. We've talked about the promise being unconditional. We've talked about the date that it will be payable, then the consideration in monetary terms, and above all, remember we said that it must be in written form. Go by those and you'll be good to go with that question. So let's move to the next question. The next part of this question. Explain the jurisdiction of the magistrate's court in proceedings of a civil nature. Explain the jurisdiction of the magistrate's court in proceedings of a civil nature concerning matters under the African customary law in your country. Oh, this question was not so specific which country. They are just talking about in your country. So it's a general question, and jurisdiction is basically the powers that the magistrate's court will have in proceedings of a civil nature and matters under African customary law. So what are these areas that the magistrate court can basically adjudicate over that are of African customary nature? African customary nature. And when we talk about African customary law, there are issues that come outrightly issues of marriage and divorce, definitely. Issues of marriage and divorce stand out. Then we also talk of, so we'll start with marriage issues, marriage, divorce issues. This will come out clearly. The magistrate court has powers or jurisdiction to handle cases of marriage or divorce. And if you check marriage and divorce, these are cases of civil nature. They are not criminal in nature. They are of civil nature. Civil nature is among individuals. No, some cases among individuals. The state is not involved. So marriage, divorce. Then we also have cases of, can talk of seduction and pregnancy. These are cases that can be handled at the magistrate's court. We also have cases of land tenure. Of course, land tenure, if held under the customary law, if done the local way. So land tenure, cases of land tenure can also be handled at the magistrate court. He has power to handle such like cases. Cases of adultery or enticement with, married person or something like that. Those will also be handled here. Cases of widows, children, custody, guardianship. These are cases that the magistrate court has jurisdiction over. We talk about adoption, legitimacy. These are cases that the magistrate court can preside over. We also have the issues of succession, of course, under the customary law, the custom way of doing things. These ones can also be handled at the magistrate court. All these are of civil nature, and they involve the customs of the people in question. So the magistrate can handle all these cases. I think we've talked about administration of the interstate estate, that is succession, inheritance. Those cases, all of them can be held at the magistrate court. So you are supposed to explain any of this, and because the question is explain simply means when you state you get one, when you explain what you have just stated you get another point. So the examiner expects 3 points, and each point possibly will give you 2 marks. That is how the 6 marks will come into being. So marriage, divorce, explain what marriage and divorce is, and possibly you can use your culture to explain some of these things so that the point actually gets to be understood by the examiner. Okay, let's look at the last part of the question. Discuss 3 types of disclosures that partners in a partnership must make. 3 types of disclosures that partners in a partnership must make. And for this question, I chose to go to the Partnership Act. And this is found in section 10, duty of good faith and disclosure. This is in a Partnership Act. So in relation to the matters of the partnership, a partner shall keep, number 1, a partner shall keep each of the other partners or their legal representative informed of all matters affecting the partnership. A partner shall keep each of the other partners or their legal representative informed of all matters affecting the partnership. So discuss 3 types of disclosures that partners in a partnership must make. And number 1, we'll talk of all matters affecting the partnership. That is the first type of disclosure, all matters affecting the partnership. Then number 2, I'm getting this from the Partnership Act. Number 2, a partner shall account to the partnership for any profits or benefits derived by the partner without the consent of the other parties from any business of the partnership or the use by the partner of the property of the partnership, the name of the partnership, or business connection. So, 3 types of disclosure that partners must make. We are talking about any profits or benefits derived from the partnership. Derived, not really from the partnership. I think we're talking about derived by the partner. Derived, sorry for that. Derived by the partner. Any profits or benefits derived by the partner without the consent of the other partners. Without the consent of the other partners from any business of the partnership, the use of partner property, the name of the partnership. So if it's related in any way with the partnership business, and one of the partners has just benefited or made some profits, then he needs to disclose that to the other partner. Then number 3, which will now be the C in our Partnership Act, is, sorry for that, number 3, a partner shall account to the partnership for any profits derived by the partner from a business carried on by the partner without the consent of the other partners, which competes with and is of the same nature as the partnership. So disclose anything that will bring about conflict of interest. Anything. So this can be a business that is doing almost the same activities as the partnership business. So if you have such like a business that can compete with the partnership business, then you have a duty to disclose that to the other partners. So discuss 3 types of disclosures that partners in a partnership must make. Number 1, conflict of interest. Number 2, any profits or benefits derived by the partner from the partnership. Then all matters affecting the partnership relationships.